Hi folks, I'm Greg McLawsen, the Affidavit of Support lawyer. I help green card holders bring federal lawsuits to enforce the USCIS form I-864. One scenario that comes up in these cases is the question of whether a green card holder can recover support under the Affidavit of Support for time they spend outside of the United States. Can you do it? The answer is yes, but let's look at some of the details and some of the scenarios that tend to play out in these cases. First, in terms of the statute, there are 5 specified events that end in the obligation of a sponsor. The ones that come up the most often are when a sponsored immigrant has 40 quarters of work, that's 10 years, or if they become a U.S. citizen. There's also a terminating condition that applies when a green card holder loses status as a resident and departs the United States. But notice that's something that's called a conjunctive rule in law. So 2 things have to be true for that terminating condition to apply. The green card holder has to both lose status and also depart the United States. So what does that tell us? If the green card holder departs the United States without losing status, the Affidavit of Support has not been terminated. So that means that if a green card holder leaves the United States and hasn't forfeited U.S. residency, which by the way takes this very specific deliberate process, or if the person hasn't lost their residency through rescission process or through removal proceedings, they're still a resident. So that means the Affidavit of Support is still enforceable. And indeed, in my practice, we've had a number of cases where plaintiffs successfully recovered money for time that's spent out of the United States. I think probably where we see this the most often, I've seen it in a lot of South Asian cases with folks from Pakistan, Bangladesh, or India, is the individual will go back home. Often this is following a divorce. So a lot of times you'll have somebody who came over on a K-1 or immediate relative marriage-based visa. The marriage didn't work out. And kind of as part of the healing process, my client, the green card holder, will go home and spend some time with family. Sometimes this is relatively brief, just for a month or 2, but sometimes it can be for a half year or so. In that case, usually that person is not working. Sorry, my computer wanted to go to sleep there. Usually the person isn't going to get a job when they go back temporarily to spend time with their family. And so they're unemployed. The benchmark for whether you can recover support under the Affidavit of Support is the difference between your income and 125% of the poverty guideline. So if you're unemployed, you've got a claim for currently about $1,500 per month. So if you've got 6 months when you're traveling abroad, spending time with family, and not working, that is recoverable under the Affidavit of Support. And indeed, as I had mentioned, that's something that we've successfully been able to do in a number of cases. Now, I think where you would get into more problematic territory is a scenario where somebody has departed the United States and they've really uprooted and left. So you've got somebody who came over from the Netherlands, got married, got their green card, they were here for several years, things didn't work out, and they pack up all of their bags and move back to the Netherlands, and they've been there, for 5 or 10 years. Well, that person's residency hasn't been revoked. They haven't lost it in removal proceedings. I think you're going to have a harder time arguing as a plaintiff in that case that you're still entitled to support. And I do think you have probably a colorable argument under the statute. But judges are also going to think about what's the purpose of the statute. And the purpose of the statute is to ensure that somebody has financial support specifically so that they don't become dependent on U.S. taxpayers for support. Well, if you've completely moved back to the Netherlands and you've got a new life there, you're now no longer at danger of becoming reliant on U.S. taxpayers for support. So that's a pretty far out there claim. I think most people in that situation wouldn't believe that they had an entitlement to support, and I've never seen a case like that work its way through the legal system. But that's a scenario where I could certainly imagine a judge having a hard time applying the strict statutory terms, even though on a strict reading of the statute and regulations, I think that person in the Netherlands, if they're unemployed, could have a potential legal claim under the strict terms of the statute. But again, I could imagine a judge feeling a really strong pull of legal intuition not to deliver that result. But to return to the scenario that's much more common, where you've got somebody who spends time outside of the United States on a temporary basis and returns to the United States, that's again something we've seen pretty often, and there's absolutely no question in my mind that that person is entitled to support, and again, we've been able to recover that in the past. Hope that's helpful. If you have any questions about enforcing the Affidavit of Support, try to stump me, drop into the comments. I'm happy to answer questions there. If you would like an individualized consultation about your rights under the affidavit, reach out to soundimmigration.com, and we're happy to set that up. Take care, everyone.